Hello, everyone. So I think we need to start by acknowledging that oil and gas is a really broad concept, and that's going to involve everything from subsea systems, FPSOs, offshore, onshore pipelines, processing plants. So each of those different packages are going to have its own issues and its own complexities. But stepping back and I guess looking at it from a more macro level, there are some particular characteristics in relation to oil and gas projects that feed into the way that claims are dealt with and how disputes are resolved. And I should say that I'm going to talk about this very much from my own experience, which I think is going to be somewhat different to some of the other people on the panel, which is good because that makes for a more interesting session. But I tend to work on very big oil and gas projects in Northern Africa, Middle East, Australia, and some of Asia. And in my practice, I tend to see pretty much only bespoke contracts rather than any standard form contracts. And in terms of claims and disputes, that gives rise to several issues. The claim mechanisms might be different to what the contractor is used to. So that is in terms of notifying claims, making them, updating them, pursuing them, and then also the dispute resolution clause might be different, and the contractor will need to be really clued up on the precise contract and how those mechanisms work in terms of time periods and content requirements. I tend to see only international arbitration clauses, usually with a tiered dispute resolution clause that involves some sort of executive level negotiation, at least at the project level, and then quite often also perhaps at the executive level outside of the project. I don't or very rarely see dispute boards, certainly not standing, which means that the parties often don't have that procedure available to them to have an independent view or assistance with resolving their claims during the project before they sort of evolve into very large disputes. The other important point, I think, about big oil and gas projects are the stakeholders. I think Paul mentioned this in the earlier session, but generally speaking, there's only a handful or a couple of handfuls of contractors and also oil companies who do these types of really large projects. So that means that the ongoing relationship is really, really critical, not only between contractor and owner, but also between contractors and major equipment and technology providers, because they're probably going to need each other to pitch as a JV for future work. So that really leads to a bit of an impetus to avoid disputes and try to amicably resolve them without going to arbitration. It also tends to mean that parties stay away from doing drastic things like terminating contracts, which obviously usually leads to very large disputes also. Now, things become a little bit more difficult when you have national oil companies involved. This is something that Andrew brought up in the previous panel. Once you have state-owned entities involved, it can become very difficult, particularly if the project is of national or political significance. There's going to be a lot of additional scrutiny as soon as projects go late or overpriced. So in many jurisdictions, that just means people might lose their jobs, but in some jurisdictions, it actually means that people will be subject to personal liability, also criminal investigations. And I've been involved in a number of matters where you've had project directors end up under house arrest and subject to criminal investigations for allegedly misusing public funds because they have made certain commercial agreements during the project and have, negotiated certain claims or made other sort of advance payment agreements. So in those circumstances, owners are going to be very hesitant to compromise on claims during the project, and they will really look to having a third party who will provide some input, whether it's by expert determination and binding or just an opinion, but they will really want something from a third party to say, look, we got this is what we relied on, and therefore the deal that I did on this claim or this dispute is reasonable. Now, we've heard a little bit about expert determination, and we're going to hear more, but I think it comes in, it's very handy in circumstances where, as we've heard, you've got discrete issues, whether it's technical or smaller value claims, because sometimes you don't want to, especially during the project, pursue a large arbitration, which is going to be timely and costly. So I think Sean is going to be speaking more about expert determination, which will be good, and I'll probably leave it there.
As a director of a number of energy companies, my ears pricked up when you talked about arrest. So I wondered if
Yeah.
I wondered if you could just say a wee bit more about the circumstances in which that happened.
Yeah, there's been, so I was involved in one, but our firm has worked on several, particularly in Latin America, Asia, and also Northern Africa, and one in the Middle East, actually. So it does happen a lot. And it was essentially people who were quite high up in on the project, so project directors, and essentially they were accused of misusing public funds because they entered into commercial deals. Some of them were, really basic, as in agreeing claims variations that maybe weren't properly substantiated, and things that were really quite, vanilla at the time, but then something happens politically, maybe a new government, or, there's a lot of scrutiny about the project because it's severely over budget, and then all of a sudden you see people trying to point fingers, and I've had, several people under house arrest for years, basically, and it's pretty scary stuff. So one recently in Latin America, we ended up winning the arbitration. We're acting for the owner, and even though the dispute or the award basically held that the owner did nothing wrong, that still hasn't sort of impacted the criminal investigation that's happening around that, and those people are still under house arrest. It's obviously looking a little bit better now, but yeah, it's something we actually come across a lot.
All right, let's move on to look at a procedure that often crops up in oil and gas. Andrea has made the fundamental point that DABs, as much as they're advocated by FIDIC and other contracts, are not really a player when it comes to oil and gas. Certainly internationally, mediation does appear to feature, albeit ad hoc or sort of pushed on people at certain points. But Christian.
Yeah, thanks very much, Hamish, and thank you for attending this splendid seminar. I met somebody at lunch who said I should perhaps have the prize for traveling the longest. I hope not. But I'm from Copenhagen, Denmark, and the law firm that I'm partnering is called Bruun and Hjejle. You cannot pronounce it. And that is the whole purpose of it, because then you'll remember it. So after this hour, you'll be asked to say Bruun and Hjejle, which is it's a bird. And speaking of birds, it's a bird. Hjejle is a bird. It's a long story. I won't tell it now. Perhaps afterwards. That lives on the shores of Denmark, perhaps also on the shores of the UK. I don't know. But Hjejle brings us offshore in oil and gas, and Hamish said mediation is certainly a feature that is activated a lot in oil and gas. And considering how I should approach this, I said perhaps I would take 3 examples of experiences of mediation in oil and gas from a country where mediation is not developed. I mean, in Danish and also in Scandinavian, it's also called mediation, because it's a UK or Anglo language term that is not invented in our jurisdiction, but we have learned to work with mediation. And therefore, as the parties in oil and gas projects need support in avoiding that disputes explode, because the oil and gas projects are very often very large and they have very big professional parties, and there's also both an environmental side to many of the projects, there's also a political side to many of these projects, so that time is of essence, or project is of essence, meaning that those projects cannot and should not buy, for a number of reasons, ultimately to ensure that energy and facilities are supported to the countries where oil and gas is needed. Mediation features have been developed quite successfully in the Norwegian and the Danish part of the North Sea, which is where I have been experiencing those models. I think also in UK, the model that I'll be mentioning is called PRIME. It's also called PRIME in Norwegian because the words are basically the same, but it's an abbreviation of Project Integrated Mediation, whereby the parties working both in oil and gas offshore via the reference or by a reference in a standard form contract, which ultimately, as I know, was developed in Norway, accept in the contract to be governed by either an ad hoc expert or a board appointed with the contract to decide upon disputes during performance with a binding effect on the parties governed or performing the contract. And the details of it is that whenever the employer instructs the contractor, leading to the contractor instructing the subcontractor, then the contractor can ask for a variation order. If he's of the opinion that this is outside the scope of work, or an acceleration, or wherever it might be, and if the employer agrees, then he will issue a variation order. If he does not agree, he remains to have the opinion that it's an instruction, then the contractor can ask for a disputed variation order, which is a very formalistic system. And if you don't follow this formalistic system, you just have to perform the work. So, of course, as we know from the FIDIC rules, there are specific deadlines by which you have to ask for these instructions or announce that you ask for a dispute variation order. But that system has, because it is widely accepted in the oil and gas sector in Norway and Denmark, and also has the effect that the decisions or the recommendations from the mediator have a binding effect on the project and needs to be followed, then they have been very effective in ensuring that projects are performed, not without disputes, but ensuring that disputes are handled throughout performance. So that was a good example, in my opinion, of mediation integrated in the project, and it's been so successful that now the model has also been applied onshore in Denmark, not with a similar typical or successful effect, because the projects are different. The projects are also smaller, and typically the employers don't have the same understanding of the need of having the decisions from the mediator or from the expert to become binding. So examples have been that even though public employers have in their procurement document accepted that they rely upon PRIME or rely upon project integrated mediation, effectively they have tried not to be bound by it. For instance, by trying to influence the structure of the dispute adjudication board or the mediator, so that there is effectively not an effective board that assists the parties during performance. And that in itself has led to a number of disputes. In itself, the disputes on the merits of the project, but also a number of disputes specifically related to employers breaching the mediation clause and not accepting that when you invite a number of internationally experienced contractors to perform a project where you refer to prime as a concept, if you then don't follow it or don't accept it and include it in the way that you govern the project, then you are also on that basis breaching the contract with substantial consequences. We have a number of disputes where the contractor has actually terminated the project in general because the use of the mediation clause or the prime clause was not followed by the employer.
Can I just two quick questions, just so I understand it? It's a prime contract.
Yeah.
You're the employer. I'm the contractor. I can raise any dispute to the prime mediator.
Yeah.
Yeah. But I think you said the mediator makes a binding decision.
Yeah.
Which is different to sort of the way most people understand mediation. It's sort of more of a process to get the parties to agree something. So it's definitely a decision that the mediator then makes. It's
a decision that is binding. Of course, either party can refer to arbitration, but it's binding on both parties until an arbitration tribunal decides otherwise.
Got it. And the second question, what if I raise a claim or a dispute to the prime mediator, you don't participate, what tends to happen? If anything, does it go to court, or can I just sidestep it and go straight to arbitration, or is it just a blunt process?
If you refer a dispute to the mediator will have to decide.
Even if you don't participate?
Yes, certainly.
Ah, okay.
Yes, certainly.
If you hadn't gone through the prime process and you sought to commence an arbitration, then you'd have a good basis for saying that the arbitration couldn't proceed, that the dispute had not arisen. How is that managed?
I think you have examples of disputes that have not been governed by the prime mediator, but can still be advanced to arbitration if either party have not observed that these issues were to be governed by the prime mediator. But in general, the system is that if a dispute has not been advanced through the mandatory procedure within the prime mediator, then there is no dispute, basically.
So you can't go to arbitration?
No.
Unless you go into,
no.
Or at least started?
No.
Okay. And is the mediator somebody that is named at day one and stays with the project, or can you have many different people?
It can be either or. Often it is somebody who's appointed from the beginning by both parties. It's a group of three mediators that work together. So you have a blend of experiences, and sometimes it's an ad hoc mediator that is then imported into the project.
See, to me it sounds a little bit like a DAB, just a different label, unless I'm... Sean, any thoughts on that? Whether you think it is a DAB in disguise?
It's akin to it. It's not exactly the same. The traditional sort of FIDIC model dispute boards, dispute adjudication boards, they're supposed to help avoid disputes. They can give informal opinions, and if necessary, give a binding, an interim and binding decision. So it is similar.
It is.
And there's obviously been inspiration from what other sectors are doing and other countries are doing. If we step back in time 50 years, if a lot of people pick up an oil and gas contract and look at the dispute provisions, it hasn't really changed. We've seen radical changes in a lot of other sectors, and then the forms of contract and the way that they're using tiered dispute resolution. Most of the big oil and gas projects, essentially may have tiered dispute resolution, which isn't necessarily binding or interim and binding, and then you've got that final point, never litigation, it's international arbitration. You know, things haven't changed. There hasn't been much inspiration from other sectors either. I don't know why that is.
Sure. Just remind us again, prime means what?
Project Integrated Mediation.
Got it.
PRIME.
Got it. Thank you. All right. I'm going to hand over to the next topic, which sort of bleeds out of what Christian has just explained, and that's really expert determination, which again, as Andrea has explained, is not always a step in the multi-tier dispute resolution process. But Sean, do you want to give us some thoughts on?
So I'm going to say a few words about expert determination, and I think it's interesting. We've had two experiences recently where expert determination was used. The contracts themselves are in very different locations. One was in Canada, the other one was in the MENA region. The Canada matter was an ad hoc expert determination, and it was a sort of traditional expert determination. It was a mechanical engineer to look at a valve and make a determination on this particular valve, and if it was working correctly, if not, and was it a manufacturing fault, or could it have been EIC or something else? So that's sort of traditional route, or the traditional way that we see expert determinations used. I've got to say, on the whole, I don't see many oil and gas contracts with expert determination in there. The one in Canada was an ad hoc matter, and the next one I'm going to talk about is the MENA matter. That was an extremely interesting one. There'd been a dispute, the parties had compromised the deal, and then there was a expert determination later on in the project to determine if commissioning and startup could be completed in line with the agreement, and that meant further funds were going to be released. It was extremely unusual because we were first approached by a law firm who said we need one person to do an expert determination. Started looking at it saying, well, you either need a commissioning and startup expert as the lead, or you need a delay expert as the lead. And looking at it in the amount of things that had to be reviewed and looked at, you're saying you're looking at about a 20 or 30 person team. You had to go right through all the project QA, QC, as well as inputting into programs. You had to go back through the construction records. It's extremely unusual. And what I'd say is, it's quite clear that the oil and gas industry is very conservative in the way its contracts are drafted. And both of these are examples where people involved in these projects realised the contracts weren't fit for purpose in terms of ADR and use of ADR, then they've gone outside of the contract to reach an agreement on a form of ADR. I don't think we're ever going to see adjudication used like it is in the United Kingdom in terms of that as a dispute forum. But it's interesting that people are recognising that they do have problems, they want to resolve them. Quite often they need something done quite speedily. And then how do they do this? These two examples, expert determination.
Does anybody have an observation or a question? I've got a couple of points for Sean. So Sean, I'll start. I think you're spot on, Andrea spot on, that expert determination isn't always a step. It can be very, very useful, but two things we've encountered. One is there's a great desire to get an expert to give a technical opinion that can then unlock design or performance, but parties don't necessarily want it to be final and binding. They just want it just to sort of guide the process. That's number one. So if you want to elaborate, any thoughts on that?
I've seen that many expert determinations that have done on an ad hoc basis, and each time they're different. A couple of times they've agreed to do expert determination, but they've never been able to agree on the terms of reference to the expert. So it's not gone anywhere, which seems ridiculous, but you know, it's one of those things when people fall out, what should be the simplest task becomes extremely complicated. That's why you often find that people will make some provision in the contract for expert determination and then link it to a process. So, for example, they may steal parts of the ICHEME contract for expert determination. I know Academy of Experts have a process for expert determination. I'm not seeing that used in oil and gas, but I can see things that have been lifted from their process and put into a clause.
Yeah. And the second issue that you sort of come across is the parties may be convinced to go to get an expert determination, but then one party thinks, well, hang on, we've got a determination process. It's in clause 3. It's the engineer's determination. So how does this ad hoc process sit with the engineer's determination process? So it ends up lawyers having to work out who's got jurisdiction, what's final and binding. So the utility of the expert determination process almost becomes lost because you need it. Time is of the essence. Again, Sean, would you like to elaborate on anything there?
Just what you're saying, oil and gas, you may have an extremely complicated plant, but essentially if something isn't flowing in a pipe at one end and coming out the other, there's a phenomenal amount of money being lost. Yeah. parties are willing to say, right, if we get this, overcome this one hurdle, that's why you have these technical expert determinations on a narrow issue. As soon as it becomes more than a single discrete technical issue, it becomes extremely complicated. Drafting the terms of reference, the information, how the process is going to work, what the input is, who's actually making the determination. So I talked about a process where you needed a team of very different experts, but one person had to be the lead person. Trying to reach agreement how that's going to work is extremely difficult. But parties will battle through where they both have a common interest, and that's delivery of the project. And it may be that the contractor is incentivised because the client's extremely wealthy and he's prepared to chuck money at the problem, realising that chucking $1 million or a couple of million out, maybe just an hour of production.
Sure. Does anybody here have any first-hand experience of expert determination?
Thank you, Hamish. I mentioned in the previous panel that it's one of my favourite processes. However, at lunch I was speaking to a couple of colleagues here, and I came across a recent invitation to be an expert determiner that I had to turn down because one of the parties would not accept my terms that included immunity, which is something that's automatic in statutory adjudication and also under the Arbitration Act, but not in a contractual ED provision. It was a screw up by the drafter of the contract, I guess, who didn't give enough thought to individual concerns that might arise. But yeah, ED is a great process, and I think that there should be more of it.
I was just going to say, I think a ripe area for expert determination is over the terminology, the technical terminology being used with new technologies. Where there are new technologies, you quite often get a situation where people think that a particular term, which has almost become jargon, has a specific meaning, but then another party thinks it has a very different meaning, or it may be simply the interpretation of a piece of what is quite normal language, like control, that this computer will control this piece of equipment, but two different parties have two different understandings of what control means in that situation. So it's the terminology itself, but also the context in which the application of the term is being used. And I think for legal expert determination, this is a pretty ripe field.
Sure. Thank you for that.
Can I just say,
Sure.
aside, I've been involved in projects where somebody's gone through every single specification and taken out the abbreviations to produce a consolidated list of abbreviations. And you may end up with 6 or 7 items all with this same 3 or 4 letters. Trying to make sense of that when it's connected topics, you do need a technical expert.
Sure. But I think what I take from Philip and from Donnie McKinnon, I think there is a dichotomy of using expert determination during the construction process in order to continue performance and so on, as against it being something at the end of a dispute end of a project where you are trying to analyse the dispute. I think it's difficult to say, let's use expert determination there because everybody says, well, let's go to arbitration because it's both are final and binding. But I really do think expert determination during the process is a very good thing, but underused. And I know Sean's a big advocate for it, but it is still largely misunderstood.
Can I ask you a question? Has anyone ever seen expert determination used after a project's been completed? 1 person, 2, 3, 4, 5, 6. I've never seen it.
I'm from Australia, and actually we have the courts have the power to order what's called a referee, which effectively is just an expert. So I've had one matter where I've seen it work really well, where it was a sort of septic tank gone wrong, fairly simple legal questions, but fairly complex technical sort of corrosion evidence required. So this was in the federal court, and the judge just ordered that the entirety of the factual issues be determined by an expert. Referred it, the parties made submissions, and eventually did a sort of mini expert determination within the broader proceedings. and then it went back to the judge, and the judge only had the sort of legal question the legal questions to answer. So it was quite an effective hybrid, I think.
I see. So the referee's not deciding something on a final and binding basis. He's just assisting the court on a technical issue.
So I think it was final and binding on the technical issues, and so basically the judge set a number of questions and said, I want to know your view on ABC, and then based on accepting this as final and binding as a question of fact, I will make my final and binding legal decision.
Sure. No, thank you for sharing that. That's very interesting. Okay. So,
Can I just comment on that?
Please.
Sure, because coming from continental Europe, I mean, that is the starting position for any kind of determination by an expert in many continental Europe countries, where you have a court-appointed expert being asked either by request from either party or appointed by the court to give estimations or evaluation of technical matters in the support of the judge or the arbitrators. And therefore, party-appointed experts is a rare bird in our countries, whereas court-appointed experts is the usual approach.
Great. Thank you. Sean, with your kind permission, I'm going to leave expert determination. Is that okay?
Yeah.
Great. The next topic is really one for Brandon Malone, and this is to look at oil and gas in the context of logic contracts, which a number of people will know are used in the North Sea.
Thanks, Hamish. I should say in Scotland we do have court-appointed experts as well. It tends to be on lower value things than they are binding, where they farm part of it out. So North Sea oil and gas. I'm going to talk about the UK continental shelf. Andrea was covering the rest of the world, I guess, but I'm going to focus more on the North Sea. So I want to look at the types of contracts used in the North Sea and then the dispute resolution mechanisms in that. The North Sea, obviously, being oil and gas coming out of there for quite some time now. I'm from Aberdeen, and we've been told it's going to run out tomorrow for the last 40, 50 years. It's not going to run out. We're not going to exhaust it ever, because it's going to become uneconomic to extract it. So there'll be, I think, eventually a lot of it left in the ground. But Aberdeen is. I don't live in Aberdeen anymore, but it's currently suffering a bit with the lower oil price, and that will tend to go up and down. But there are many places where you can get oil out of the ground more cheaply. Anyway, that will give rise to part of what I'm going to talk about. So the types of contracts. Oil and gas is a huge enterprise, many different types of parties involved. So at the top level, you've got licensing agreements with the government, agreements for exploration, agreements for production. You might have production sharing contracts. You've got joint operating contracts to spread the risk. You've then got service contracts where companies are coming in to the big players and providing services to them. Farm in and farm out agreements where somebody's trying to get into an existing field or get out of an existing field. Decommissioning contracts, which are going to become more and more relevant, and sale and purchase agreements, and up and down the contract chain, many different types of contracts in addition. So many different types of players in that area. The logic contracts, which stands for Leading Oil and Gas Industry Competitiveness, is, I feel they maybe strained that a little bit so they could call it logic, but it's a nice acronym. But anyway, so they've got a number of standard forms, as you would see with FIDIC and JCT and SBCC and all these NEC, all these people. They've got general conditions for services, marine construction, obviously a major aspect of offshore oil and gas, supply of major items of plant and equipment, design and construction, offshore service vessels, drilling, and operations and maintenance. So they've got various standard forms. And the types of disputes that can arise, quite a lot of parallels with construction, obviously, during the stage where rigs are being built and what have you. payment disputes, scope of work disputes, quality of work disputes, change orders and variation, delay, extension of time, health and safety and environmental compliance, a major issue offshore, force majeure events, suspension and termination, warranty and liability claims, intellectual property, a lot of intellectual property in that sector, insurance, performance, and obviously usual contract interpretation disputes. So there's interesting dispute procedures within the logic forms, and I want to talk about the decommissioning project in particular from 2018. So it's a multi-tier approach, and there's a heavy emphasis on trying to settle things initially through negotiation. I think historically, when the oil price was very high, there was money sloshing about all over the place in the North Sea. Things were just sorted out at executive level without formalising it too much. But obviously, as the price comes down, as margins tighten, as you've got smaller players involved who have made investments based on particularly if they made an investment based on an assumed oil price and that price is going down a lot, you get a lot of tension and a lot more formalised dispute resolution. So the process is you serve a notice requiring negotiation on the other party. And the designated representative of the employer and the contractor shall discuss the matter in dispute and make all reasonable efforts to reach an agreement. And they have to do that for 40 days. And if they haven't reached agreement within 40 days, then there's an escalation provision, and you then get negotiation by appointed persons. So the appointed person, who will be more senior, more influence in the company, then has a period of 20 days within which to try and reach an agreement with their counterpart. And if they're not able to do that, then it gets kicked upstairs, and then you have negotiation by senior executives. And that stage lasts a further 20 days. So you've got an 80-day period within which there's escalating negotiation. And you can see why this makes sense. The people, there's no point involving senior executives in every dispute. But the people at the coalface, they will have maybe an emotional attachment to the dispute. They may have a vested interest. Their bonuses may be attached to the outcome, for example. So it goes up to middle management, who will maybe perhaps take a more detached view, and then ultimately to the senior executives who can take the broad view of the good of the company. So the theory is that you eventually get to a dispute, a resolution at one stage or another of this. But if no agreement is reached, what the form then says is that parties may attempt to settle the dispute by a form of alternative dispute resolution to be agreed between the parties. Now, ADR, obviously a very broad term, I think used synonymously with mediation most of the time, but can mean other things, could mean expert determination, for example. So there's an encouragement to do that. It's not compulsory. I think most people would take that to mean mediation, but it's not compulsory. So that's the fourth stage. And interestingly, the provision is then, if no agreement has been reached after the negotiation and the ADR stage, either party may refer the matter to the courts, or arbitration is specified, or to adjudication under the scheme for construction contracts. So this is an interesting bleed over from construction adjudication into oil and gas. I haven't come across any myself. Half my work is as an adjudicator these days. I haven't seen any arising out of these contracts. I think there is within the industry maybe a wariness of it, but they're just adopting the scheme wholesale. But as I said, I don't think it's being used heavily yet. But that then, if there is this adjudication process, it is binding on an interim basis and has to be complied with, and then there is the right to go to court or arbitration if specified. I think in these contracts, people do tend to leave it as court, so the High Court is the ultimate. I should say all these things tend to be written under English law with the English courts, and it tends to be the High Court there is an encouragement in the guidance to use arbitration for cases where there's a heavy maritime element, but it would depend whether that's specified or not in the contract. So I think with arbitration, what we see globally, as Andrea was saying, is that there's a preference for arbitration rather than litigation. We see this in the research that's done, the Queen Mary research. I'm a co-director of the International Centre for Energy Arbitration. We did some research, and that was very much the message that came back from the international respondents was arbitration's preferred method. But in the UK, there's quite a bit of litigation arising out of the North Sea. So conclusions, very common to have disputes because of the environment in which this is being carried out. It's like a construction project in the middle of the North Sea, so you can imagine how that's going to go. I think decommissioning is going to provide a lot of work for many years to come, but you can see in these contracts there's a very heavy emphasis on a requirement to negotiate, potential for adjudication to come in if the fear of that is overcome in the industry, but otherwise we are looking at litigation and arbitration.
I'm going to make an observation. It's interesting that they're using adjudication, and they said that it's going to be for the scheme for construction contracts. The one thing that I can see is, and this has happened in a number of offshore matters where I've been consulted by shipping lawyers, they say, right, we need to find an adjudicator nominating body. The question is, where do you go? It's a shipping or oil and gas matter. If you look at the traditional AMBs, most of the people on their panel don't have any expertise in those fields whatsoever. So that's certainly a question. It's probably something, if you are going to use the logic form, you may want to tweak it to the extent that you name a suitable AMB or give thought to the adjudicator.
The point that I was going to sort of socialise, Brandon picked up on it. The issue here is where, in logic, you sort of contract into the Construction Act. And let's assume it's not England or Wales, but Scottish law. The question then is, where do you enforce the decision? Is it arbitration or is it in the TCC? The Van Ord case that was heard, I think last year, the year before, suggested once you contract into the scheme and the Act, you've contracted into everything, including the enforcement regime, therefore court. But as Brandon has alluded to, where you've got arbitration as the final and binding step, and you contract into adjudication, are you then stuck in the arbitration track, or are you allowed to sidestep back into litigation? Much will depend, I guess, on how the Scottish courts analyse it. That was just an observation, not necessarily a question.
It's an interesting point. I mean, I think it does specifically say the English scheme, and these contracts are always written under English law by and large. Certainly at the top level, some of the service contracts you get more Scots law. I think there are. I don't know. I think I would probably go to court to try and enforce it until somebody told me I couldn't, because otherwise you've got an interim step. I suppose there's parallels with the FIDIC contracts where you get a decision from the Dispute Avoidance and Adjudication Board, and you then to enforce that. Obviously, if they don't put in a notice, it becomes final and binding, and you can do what you like with it. But if they do object, you can still enforce it. But if the arbitration is the option, which it probably will be, you then have to go to an arbitrator, and you then get an arbitration award. And there's been interesting cases in Singapore about that, the Persero cases, where the Singapore courts, notwithstanding that it's not final because there's been this notice, have been willing to say, yes, arbitrator, you can just do a rubber stamp on this, and we will enforce it. So I guess you've got parallels with this kind of thing, but I think I'd be inclined to go to a court with a decision coming out of this to enforce it, skip that stage.
Gideon?
So last year in the Allenbuild case, or maybe it was the year before, I can't remember, there's Allenbuild and then Van Ord. And in Allenbuild, I was unsuccessful in doing a full throttled attack on the previous case law that you could take adjudications where there's an arbitration clause to court and enforce them. And His Honour Judge Hodge, Casey, QC, can't remember which side of the line that was, said, no, that isn't right. Mm-hmm. The way that it works is if you get an adjudication award, a decision, I should say, then the Act effectively entitles you to take it to court if you want to enforce it, unless the clause provides to the contrary. And that was picked up in Van Ord as well, where, going to say Mrs. Justice, so Farrell, but perhaps I'm wrong about that, reached essentially the same conclusion. So it seems that we're in a situation now where some of the older case law, which suggested that you couldn't ever contract out of the right to go to court to enforce adjudication, is wrong, where if your clause says that adjudication enforcement must be resolved in the arbitration, then that's where it must be resolved. But if it doesn't, and it says that if it doesn't, and it's silent as to it, then probably you can go to court or go to arbitration, or possibly both.
So, talking of bad conduct, Rob, the extent to which a party's bad conduct during a dispute resolution provision is the topic of Gideon's talk. So over to you, Gideon.
Corruption, fraud, naughtiness. It's fair to say that the oil and gas industry and oil and gas disputes, at least in my experience, has a disproportionate number of cases in which particularly state entities, particularly after a change of government, say, well, this, however many hundreds of millions or billion-dollar claim that you're advancing is a very interesting one, but actually, you've been very naughty. This has all been procured through lots of bribes, through a bunch of money laundering. You've stolen you've embezzled a bunch of money, etc., etc. It's worth saying these obviously aren't new allegations. This isn't something that, in the 21st century has suddenly become a big change in the way that business has been done. You could go to the ancient world. I'm not going to say that, if you look at the records of pyramid building, Imhotep is put on trial for taking bribes. But it certainly is the case that if you go back to ancient Rome, ancient Greece, you've got governors being put on trial for all kinds of naughty things. If you look back at the 19th century, you see trials of all kinds of people for misconduct, corruption, fraud in building ports, in operating the East India Company, and all kinds of other things that nowadays would no doubt feature on the news 24/7, rather as the trial of the corruption of a former president seems to get 24/7 coverage. But how does it actually work? Well, there are several features of these cases that, at least in my experience, are pretty typical. You have a large contract, a large dispute. People tend not to bother to raise these issues if the amount at stake isn't very large, but perhaps others will disagree with me. There's been a change of government, or possibly a change of management in a national oil company, or a state or municipality or equivalent. They decide to stop paying, or to terminate, or to do something. And then the contractor turns around and says, right, well, you actually owe me X number of hundreds of millions or billions because you've terminated, you've expropriated my assets, depending on whether you're in the commercial or the investment treaty space. Or you've done all kinds of other, you've not paid the bills in some cases that I've had. And the state says, well, yeah, but that's because you're a bunch of crooks. And actually, you should repay us every penny we've ever paid you. And lots of more money as well. So a fairly typical fact pattern. There's obviously interesting questions about whether or not this can go to this can go to the jurisdiction of a tribunal as well as the merits. And I mean, this is obviously something that comes up in awards, both in commercial and investment treaty arbitration all the time. The recent award against Ukraine that was dismissed based on corruption is a quite good example of seeing the way in which a quite high-powered tribunal dealt with this in the context of investment treaty jurisdiction, deciding whether or not something was a valid investment. A lot of this has obviously come to a head very recently in England, and because we're in an English event, we can't not mention two things. Firstly, because this is a conference AI, we've mentioned that, so we can move on. But secondly, and more relevant to corruption, the Nigeria case. There's been a lot of talk about this Nigeria case. It was the underlying facts are someone enters into a big contract with the Nigerian state to do some energy-related facilities. They terminate it almost immediately. Contractor claims it was wrongfully terminated, and therefore they were entitled to vast sums, around $15 billion, or perhaps $10 billion. I can't remember the exact number. It's not terribly important, but a large amount of money. They have a very high-powered arbitration tribunal, including former law lords, who decide that they're right. Afterwards, when Nigeria is asked to pay the bill, people start looking into this and say, hang on a second, there was all of this corruption. What was going on there? And it turned out that people were doing various naughty things within the arbitration process, as well as outside the arbitration process in getting the contract in the first place. And this was brought to a head in a Section 68 challenge. That's a challenge for procedural irregularity. Brought out of time, but the court said, this is so significant, we're prepared to give you an extension to have this heard. And what emerged was lots and lots of bribery, misconduct by lawyers, misconduct by parties, misconduct by almost everyone, except possibly the arbitrators, who perhaps the judge was a little bit scared to criticise. And certainly there was no allegation that they themselves had taken bribes. But where it ultimately went was a debate that's really been running for some years now between what might be thought of as the sort of old-school Anglo-Saxon approach to arbitration, where the arbitrators sit back, rather like judges used to 50 years ago, say nothing, let the parties get on with things, and then act as a referee at the end, reaching a decision, and the more civilian approach of arbitrators being more interventionist. And where the judge seems to have reached is that the duty on arbitrators is, to some extent, to be interventionist, to investigate where there may well be allegations or hints of allegations of fraud and corruption on a grand scale. It's not entirely clear where this is going to go, because it suggests that it's a duty that varies from arbitration to arbitration. And it obviously presents difficulties for parties as well, because if you're representing a contractor, and you might very well look at it and think, well, these guys are obviously crooks, but I don't need to tell the tribunal that. Where do you go? Being completely silent may not be the best way of doing it now, or maybe it is. So, case-dependent question, but certainly something that provides a lot of food for thought.
Thank you. Thank you, Gideon. Martin Cooney has his hand up, but we don't have time for your question, Martin. I'm only kidding. Martin does have his hand up. Sorry, I'm only kidding. Better be good. Sorry.
Yeah, I was speaking with a colleague in Nigeria, and there's an observation before the question. And I said to him, I gave him statistics on corruption in Nigeria. And I said, what's it like to work in such an area? And he said, listen, every country is corrupt. We're just better at it than the rest of you. But the question I have is, whenever I see the issues of fraud or naughtiness come up in any dispute resolution process, they tend to be ignored. So what I find is the third party ignores the allegations, puts them to one side, and says they're a red herring. So I haven't read the Nigerian case, but I'm just interested now, the independent third party, if that comes up, are you saying there's now a court mandate that they have to interrogate that, or delve further into it and see if because any international project, you're going to have massive problems with that?
I think the answer is it depends. It depends on the situation, depends who the lawyers are that they're representing on each side. It depends what the underlying allegations are. I see a lot of cases where you're up against, what's the best way of putting this, certain international arbitration boutiques who, as a matter of course, will throw out allegations of bribery or corruption where you wonder whether or not it would be quite an English lawyer would be prepared to advance those allegations. It's not unusual, I think, where that kind of thing happens, for a tribunal to view that with some scepticism, especially if the lawyers appear to be competent on both sides and the party is competently represented. Then you have other situations where you're dealing with a very different situation, where there seem to be a bunch of things happening, and there are hints of it, but nobody's ever quite squarely putting things. And it may be that the tribunal should be saying, what are you actually saying here?
I've done this recently as an arbitrator, an uncontested case, and we just asked them, look, given recent case law, we want to be absolutely sure that this isn't a contrivance to affect a fraud, so please explain this, this and this to me. And they did, and it was fine, and we got on with it. But I think arbitrators are going to be now more cautious about these things. I think you have to be.
I think two things to Martin's question, though. I think it's a first instance decision. None of the institutions have issued any guidance following Mr. Justice Knowles' decision, the CIARB or LCIA. No one has said adjudicators, arbitrators must now do X. The issues around consent awards have been there from forever. So
there's debate about it, though. I know when they were looking at the Act, there was the reform of the Act, which is now dead, of course, in the meantime. But that was one of the discussion points, is should we add in something about a duty?
And there is also another point that query whether any of this so-called bad conduct impacted the arbitration. There's no dispute that there was in the background, but Knowles' view was it did, but others have taken a different view. It just depends. It's worth a read, that's for sure.